Hello, everyone, and welcome to Uncivil Law, where we learn through the misfortunes of others. As always, I am your host, Uncivil Law, a licensed attorney in Texas, Virginia, and before the United States Supreme Court, and I hope, as always, you're just having the greatest possible day. We are here with the Thursday Night Thunderdome, a weekly roundup of the stories that might have got in the news that you might not have seen, to make sure that everyone understands what is happening in the law recently and make sure we catch up on all the week's fun in stories you might not otherwise be watching. We need to know what's going on with it all, so we turn our attention to the many stories that happened in the law this week. We begin our attention with the estate of Aretha Franklin. Aretha Franklin, as I'm sure you well know, was a very famous singer and quite wealthy and had some assets when she died, as one would expect. And then there was a question about her will and what will was valid. And the will that winds up being valid, we literally found in the sofa cushions. Seriously. So that's how that rolls. The will that decides how these millions of dollars are going to be distributed, her estate, her assets. We literally decide how to do that based on a piece of paper we literally found in the sofa. So, the law can be an interesting and fun place sometimes. Let's learn a little bit more about this. A judge who oversaw the estate of Aretha Franklin awarded real estate to the Tsar's son, citing a handwritten will, which has the fancy name in law of being called a holographic will, if you want to look it up, lol, from 2014 that was found between the couch cushions. Now, I need to take just a moment to say that what a will needs to be legally valid depends from state to state. Some states don't recognize holographic wills, which is when it's in your own handwriting. Some states do. Some states require 2 witnesses. Some states require 3. Sometimes if it's holographic, they don't require a witness at all. I remember one case reading about in law school where a farmer was out and about, doing his farming things, riding a tractor, and, fell off his tractor and was bleeding to death. And with his last breath, as it were, started writing what he wanted to have done with something of his property in his own blood on the tractor. Well, that counted in that state because, it was in his own writing. So literally a will written in blood on at least one occasion. So yeah, but before you go about and do this and rely on this, just a friendly reminder to check your own state law. And, all else being equal, I would recommend just getting a lawyer, by the way. The most expensive wills don't cost more than a couple $1,000s. And if you have any assets at all, you probably want to get done by a lawyer to make sure you thought of things and there's nothing to contest and so forth. But, if you're going to go this route, well, we'll go that way. So fun. So the decision came 4 months after the jury said the document was valid, despite cribbles and hard-to-read passages. Franklin had signed it and put a smiley face in the letter A. Yeah, so, okay, fair. So they asked the jury, hey, is this a will? It meets all the legal requirements, at least in Michigan, or at least in Michigan. Again, your law will vary, but, all the rest of it. Okay. The papers will override a handwritten will from 2010 that was found at the home around the same time. So typically the issue is which will came later, right? Because the most recent will is obviously going to govern. And, then we only need to ask questions like, does the person, the testator, which is the fancy name for the person who's writing the will, the person who the will is from, the testator or testatrix, if it's a woman and you want to go old school, which I kind of like personally, but that's just me. What if they had capacity? Did they have enough sanity to understand what they're doing? And incidentally, we're not looking for very much. So if you have any lucidity at all, then fine. One of the sons will get the property, which was valued at $1 million, but of course is worth more. So yeah, the The will, written by hand, found in the couch cushions, decides how a million decent property gets sold. Fun. Another son who had favored the 2010 will because, it favored him, will be given a house in Detroit, though it was sold by the estate in 3000 before dueling wills had emerged. So, the question, of course, would be what the property was at the time of death. Incidentally, by the way, again, if you care about such things at law, if you identify a specific piece of an item, so if you say an item by name, right, in your will, so I give my house, it's so-and-so, so-and-so to my son. If that house doesn't exist, when you die, then there's nothing to sell, to give, right? And it's like, oh, that house sold for $250,000. I should get the $250,000. That is not how that works, because now it's just residual. So it depends who gets the cash. So if the item becomes extinguished, it no longer counts. Becky in chat says, have I talked about the case where a guy's property was in 500 feet of the school? In Montana, he's charged federally with having a gun within a school on his own property. I have not heard that case. That sounds pretty interesting. So, yeah, I haven't heard about that case. That sounds very interesting, but maybe we'll look it up someday. That sounds cool. Teddy's requesting the sale proceeds, which, again, if it was held at the time she died, then fine, but if not, then not so much. The judge awarded a third son another property under the will. Aretha Franklin had 4 homes when she died of cancer in 2018. The discovery of the 2 handwritten wills months after her death led to a dispute over what the mother wanted to do with her real estate. Sir Frank Otter subscribed. Thank you very much, by the way. Also, by the way, in case you care, just another little legal factoid, in case you're interested in much things, if a lawyer helps you draft your will, then the lawyer can testify during the hearing on the will if there's questions, because one of the things we're concerned about is what did the person want? What was their intent? And the lawyer met with the client, obviously to draft the will. And the reason the lawyer can talk about it in court is because in this instance, the lawyer is furthering their client's interest, right? So the lawyer is authorized to speak about issues they discuss with their client when it will be for the benefit of their client, right? Because, if you hire me to do a job, that job might require me to talk to someone else, depending on the job you're asking me to do, right? So all the rest of it. Not in all states, I said earlier, not in all states. I made that clear a couple times that this is state by state specific. Although you're talking about the attorney privilege, so maybe there's a special rule in Florida. So that would surprise me, but I suppose that's possible. But typically, in most states, the attorney can testify because it furthers their interest to their client, the person who is writing the will, and so the privilege issue doesn't apply typically, but maybe Florida has some special rule. Every state does differ a little bit in the rules, but that's typically a rule, so maybe not in Florida, maybe, who knows. Okay, this was a significant step forward. We've narrowed the assets on the remaining issue. There's still a dispute over how to handle the musical assets, which of course are going to be a bit of change. All those residuals are going to be a big deal, though it appeared the sons will share it, which, fair enough if they agree. Franklin, of course, was a star for many songs, including most notably perhaps the song Respect. So, yeah, this is one of the reasons I like to do these stories, because it gives you a chance to talk about some of the differing rules on some of these legal issues. They'll let you talk about, okay, can you have a handwritten will? Is that a valid thing? What is a signature? Incidentally, I remember coming up in a case because there was a case one time where it wasn't signed at the bottom, but in the will it says, and this I think was handwritten. So it said, I, name hereby bequeath blah blah blah, and so the question was, when their name was said up there, did that count as a signature? That was a case once. And then how many witnesses do you need, and so forth and so on. But please speak to a competent attorney in your state. I would strongly recommend against downloading one form somewhere from one of those websites and be like, you can download a legally valid will from the internet. Yeah, I wouldn't go that way if I were you. That seems like a recipe for disaster. But in any case, that brings us to the end of the story. All right, good evening, everyone, and welcome back to Uncivil Law. As always, I am thrilled to have you here. I'm very glad that you're here and spending some time with me. I've really enjoyed speaking to you the last couple days during the streams that we've had. We've had some great streams recently, and you guys have been awesome. Please do not use ChatGPT to create your will. That sounds like an exceptionally bad idea. Don't do that. Do you want your will to actually work? Probably talk to a lawyer sounds like a good thing. Doing it on your own seems like a problem. Yeah, but thank you for dropping by. I've really enjoyed the chats over the last couple days. It's given me a lot of pleasure, and I'm happy that you're here and that you guys have helped me so much with my audio and video and stuff like that. It's been great. Thank you very much for saying I'm slimming down on the face. I appreciate that. I've been working out and eating better and all the rest of it, and I appreciate your note. I like that. All right, let's learn a little bit more about Florida Man. Florida Man comes in many forms, not always necessarily from Florida, but usually. Florida Man does strange things, and we get to learn about the strange things Florida Man does. What did Florida Man do today? Well, Florida Man was arrested for pooping on a dead possum that was on the street during rush hour. Okay, that seems like a series of bad choices. I guess if you gotta go, you gotta go, but maybe this isn't the right way to go about it. Maybe, not the dead possum or in the middle of the street or all the rest of it. So that could be some issues. So Florida Man is arrested. I suppose he has the workings of a necessity defense. I really, really had to go. Good work. We'll see. Let's learn a little bit more about this. A Florida man has found himself behind bars after he was seen by a police officer pooping on the dead possum in the middle of the street. So the pooping might not necessarily be the problem. Incidentally, the more logical problem is it's rush hour and he's in the middle of the street and upholding traffic. So that could be an issue. The Rudy Wilcox was arrested and charged with exposing his organs. Okay, I guess we can try that too. After the alleged incident unfolded on Wednesday near the intersection of Belcher Road and Willow Tree Trail in Clearwater. Clearwater once again making the news. Here is the man looking not like he's having his best life right now. At around 5:20 in the afternoon, the 45-year-old man was seen by the Clearwater police officer defecating upon the possum with his pants down, as one typically do, and his backside was exposed. Yeah. Wilcox, who has no known residence, not a great sign, was allegedly in full view of the motoring public during busy hours. Probably could have gone a better way about it. In a post-Miranda interview with the police, at which time, of course, he invoked his right to remain silent. Of course, right? Because it's post-Miranda. The police told him that he had the right to remain silent. And he, listening to me and every other attorney on the face of the earth, said, I want to remain silent. I want an attorney. I don't want to talk to you. That's what he said, right? End of interview. Apparently not. He denied the allegations, said the officer doesn't see straight. However, the police, of course, have some physical evidence to validate his thing. So that is a problem. I guess they bagged the poop. Will the poop be displayed in court? Will a jury be handed the poop as it is published to them? Here, you hold the poop while I'm talking about it. Exciting. And he currently remains in jail, so things are having weird. So yeah, he has some defenses, Most notably, that it's necessity. I really, really, really had to go. So there's some possibilities, but we'll see how it's going, you know. Yeah, and yeah, so we'll see. So we'll be paying attention for more. Jury service isn't always taking care of Maya. Sometimes the jury cases are not as fun or not as interesting and have some more scatological elements. So, yeah. All right, in fairly major news, the appeal court in New York has considered the question of the gag order that was against Trump from the trial court, which in New York is called the Supreme Court because New York likes to be confusing. The Supreme Court is just the trial level court because they like to confuse you. So the appeal court reinstated the gag order, at least in part. We'll learn a little bit more, that had barred Trump from aligning court staff. So let's learn a little bit more about the Court of Appeals decision, which they call the Appellate Division. The Court of Appeals is actually their highest court because, again, they like to be confusing. Oh, Lord. So let's get started with this. The appeals court reinstated the gag order that had barred Trump from commenting about court personnel after the president disparaged a law clerk. The 1 cent decision came, so while the appeals process came out. So, there was a lot of discussion about this at the time. There seemed to be, from the oral argument, that the Court of Appeals was looking to narrow the decision. That seemed to be the general tenor of things. Our expectation was the gag order would come back in New York, but it would come back in somewhat of a more limited way. But apparently the appeal court wrote all of 1 sentence about it. So that's somewhat, interesting and slightly disappointing because you think they would actually do some analysis on the law and explain it, from a legal posture, but apparently, no, just go away. So the trial judge says he plans to enforce it rigorously and vigorously. So, yeah, there you go. Bafabel from Twitch says, you did your part with Prime. Chat, you do your part. Thank you very much for subbing on Twitch, which is the paid option, and we do appreciate everyone who subs over there as well. And if you wouldn't mind opening Twitch in another tab and muting the tab using the tab mute rather than the slider, or if you can't mute the tab, bring it to 1% to help with my watch time, that would be appreciated. You all are awesome. And incidentally, I contacted the people behind the bot that restreams to Twitch, and there is some sort of global problem at the moment with the bot on Twitch. So it wasn't just me. I didn't screw up something. So the problem of the bot working on Twitch's end is a problem they're dealing with. So hopefully that'll be fixed relatively soon. But it wasn't my fault. Trump's attorney called it a tragic day for the rule of law. A spokesman for the campaign complained that the gag order was nothing but attempted election interference, but pretty limited in that. They posed the gag order on October the 3rd after Trump posted disparaging comments about the judge's clerk to social media. Which, fair enough, right? If you want to talk about the judge, everyone works for the judge, so you really shouldn't disparage the staff. There's really no particular need for that. The post, which included a baseless organization about the clerk's personal life, came the second day of trial in the Attorney General's lawsuit as it relates to the businesses Trump owns. So this is the civil suit against Trump's businesses. Trump is named as a party, but Trump isn't really a party, really. It's more about his businesses and whether or not they can continue to be businesses and whether or not he can be an officer of a business ever again and whether or not they committed fraud in a legal sense that matters. Add Twitch to the link tree. I do need to add Twitch to the link tree. Fair point. Tony told me about that and I forgot. I need to fix that. I'll get back to you. The lawsuit alleges that Trump exaggerated his wealth on his statements used to secure loans. Notably, however, of course, none of the people he sent the loan applications to complained, or the banks who gave him the loans. So no private person is complaining about this. But of course, that doesn't necessarily stop things, because every business has to have fair dealings. So if you attempt to commit fraud, right, but don't succeed because the person doesn't buy into your fraud, it's still attempted fraud. You tried, right? The fact that you didn't succeed is what makes among things, it makes it attempted fraud. So the state does have some interest. Now, I will also point out that this appears to be relatively rare to unique, the way that they're going about it in this particular case. There doesn't seem to be a lot of evidence that other businesses have been held to account in a similar or comparable way in New York. So it does seem to be somewhat targeted against Trump, because Trump that's the way it's going. So making a selective prosecution case is pretty hard legally. So, as we said, just because everyone is speeding and not being pulled over and you're pulled over doesn't mean you can say, I'm going for speeding. So there is some evidence that would allow to a selective prosecution claim, incidentally. It's just a very hard thing to prove. Virginia says, isn't that the same thing as what's going on in New York City? Yeah, that's what I'm talking about. That's the lawsuit we're talking about from the Attorney General. Over the first weeks, the trial judge fined Trump $15,000 for violating the gag order. The judge expanded on the order, which initially covered only parties of the case to include lawyers, after Trump attorney questioned the clerk's prominent role on the bench. And I've heard disputed evidence the degree to which this is common in New York. So yeah. The state's lawyers supported the restriction, saying it was reasonable to protect the staff. The attorney for the court system tied Trump's comments to an uptick in nasty calls and messages directed to the judge, which isn't really cool. That isn't really nice. The public can watch. They can certainly comment in the newspaper articles. They can comment on their blogs, but not really cool. Channel Caesar says, where it's a better chat from, Twitch or YouTube? Even. I mean, it's even. Take your pick. Twitch at least is being relayed to YouTube, so everyone on YouTube's end can at least see Twitch, and you can also see it on screen, which is as good as I can do for the moment. So either way, we'll be fine. Thank you for the super chat. The court security captain wrote in a sworn statement last week that Greensfield has been receiving 20 to 30 calls a day to her personal cell phone and 30 to 50 messages a day on social media. The captain reported Greenfield received enough harassing voicemails to fill a transcript of 275 single-spaced pages. About half of the messages were anti-Semitic, which isn't a good look. Yeah. Yeah, I think the attorneys in the Maya case meant bus stop people as an insult. That seems pretty manifest from overall context. So, yeah. Trump's lawyers then argued that while the messages and calls were vile, he shouldn't be muzzled because of other people's bad behavior. To the extent he's inducing it through his public statements, he can be held accountable at least a little bit. Trump never called for violence, nor did his lawyers ever encourage or condone harassment. Yeah, but you're doing things you really shouldn't do. You can criticize the judge. Leave the staff out of it. Just say, the judge did this or whatever. That'd be fine. Jules, the book has to be called If I Am Notorious by Jules. As a frontrunner for the 2024 Republican presidential nominee, as a citizen on the trial, President Trump is within his rights to comment on what he perceives as bias. With respect to the judge and the process, sure, that'd be fine. While the gag order was suspended, Trump posted about the clerk as recently as Wednesday, referring to the judge as very disturbed and angrily clerk. Becky says, why all of a sudden are we getting ads during lives? It's new in YouTube land. It's new. Isn't it fun and exciting that now you get ads in YouTube on live streams? Isn't that fun and exciting? It's great. In recent day, Trump also assailed the family, citing critical social media posts about him that asserted came from the judge's wife. Court system personnel said that it did not. You got 2 ads within 25 minutes? Well, that's kind of annoying. The trial courts remain claims of conspiracy, insurance fraud, and falsifying records. James is seeking more than $300 million in penalties and a ban on Trump doing business in New York. Yep, that for well. Trump is due to testify for the second time on December the 11th, with the case to be closed shortly thereafter. The verdict in the non-jury case because his lawyers didn't ask for a jury. So that seems to be a Trump fail. They could have presumably asked for a jury, but they didn't even ask. They didn't even ask. The state, when it submitted the form, said, we don't want a jury. Did defense ask for a jury? Nope. So now it's just up to the judge. So that's a brilliant move there. I'm not sure how much the jury would help, but still. There's got to be some pro-Trump people in Manhattan. Yeah. If you have Amazon Prime, you can use your Prime to sub on Twitch and you won't get any ads on Twitch. So that's true. So for those of you who do have Amazon Prime, there's another benefit. Do you not like the ads on YouTube? Well, what you could do is if you have Amazon Prime and you watch it on Twitch and you link your Amazon Prime and Twitch accounts and then subscribe to me on Twitch, you won't get ads. That's true. So that's good. This is only bench eligible. I'm not sure if that's true or not, but they didn't ask. I'm not sure if that's true, but okay. Others say because it's a civil trial, he couldn't get a jury. That doesn't sound right. We have juries in civil cases. For example, Take Care of Maya was a civil case in which there's a jury. So that doesn't sound right. You don't have a normal TV because of ads? I understand. I don't have a normal TV either. Yeah. So that's the situation. And so, basically Trump, the judge is going to rule against Trump because they've already basically told you they're going to in their previous filings for the partial summary judgment. They've already kind of told you they're ruling against Trump. So the judge is going to find that Trump, committed fraud with intent to deceive in official filings, and it's systematic and pervasive, and the businesses can't continue to exist, and Trump can't be a leader of a business in New York anymore. So that's the direction where there's going. Ohio mom says the ads aren't on all channels. Perhaps there's a way to change the settings. I think YouTube is rolling it out partly by part, but I'll look into it. Thank you very much. I appreciate it. And that's the end of that. All right, turning our attention to the U.S. Supreme Court, an institution that I have a lot of reverence and love. Yeah. So the ads are good for me because it means YouTube likes my channel. Kick ass. Senate Judiciary Committee authorized a subpoena for Harlan Crow and Leonard Leo in the ethics probe, some of the major donors for that. So that is exciting. So yeah, they want to get the donors before the Senate and ask questions under oath. So we can look forward to that. Let's see what we got there. Yeah. Democrats on the Senate Judiciary Committee vote to issue subpoenas to the GOP's donor Harlan Crow and conservative judicial activist Leonard Leo on Thursday. The subpoenas were approved following a contentious meeting in which Republicans accused the Democrats of attempting to undermine the Supreme Court by targeting private citizens. You know, the Democrats would be saying the exact same thing if the shoe were on the other foot. This is one of the things I've learned about Congress. The talking points just completely flip depending on who's being hoisted on what petard. So I have absolutely no doubt in my mind, not even a little, that if the situation were reversed, we were looking into donors for Elena Kagan or something, that it would be the Democrats who'd be making the exact same argument because that's how they roll. Lawyers are seeking documents from Crow and Leo about gifts, trips, and lodging provided any member of the court. Their involvement in the trips provided to the justices were revealed in reports this year. Thank you, Sahar Silverman, for your 10 gift memberships. That is extensively appreciated. Thank you. Their attempts to thwart the legitimate oversight of Congress should be a concern to us all, says the Senate. As I said before, I don't seek this authority lightly and I don't ask for it often. But to protect congressional authority and advance the committee's efforts to implement an enforceable code of conduct, it is necessary to seek authorization to pursue the compulsory process in the Senate. Yeah. Is Notorious Jules still getting ads too? That's not great. We like Jules. Jules is cool. Jules is cool. The way they're going after you, Jules, is uncool. Yeah. The Illinois Democrats called Crow and Leo central players in the ethics challenge. Senator Graham accused Democrats of attacking the integrity of the court, which has a 6-3 conservative majority following decisions on abortions, gun rights, and affirmative action. You know, for a very, very long time, the Supreme Court was fairly left-leaning. You know, for a good 50 years there, at least, there was a liberal majority on the court. And now that suddenly the Supreme Court is conservative, all of a sudden, all these Democrats have massive problems with it. Well, the Supreme Court should be allowed to do that. Yeah. They're going after you. That means they're leaving someone else alone. That's a nice way of looking at Jules. I like that. This is about the ongoing effort to destroy the court, to destroy Clarence Thomas's reputation, to pack the court to get your way, to make sure the Supreme Court that exists can't function. There's definitely some of that. You sent me Richard Allen's reply brief in Discord. Okay. Maybe we can try to cover that tonight, depending on if people want to talk about it. We can maybe take a look at it. Democrats on the panel had also planned to seek approval of a subpoena to a third Republican donor, Robin Arkley. But Durbin dropped the demand earlier this month after Arkley turned over the information to the committee. Thank you, Fiona W., for the 10 gift memberships. It appreciates it. I appreciate it. Following the vote, a statement from Crow's office accused the committee of Democrats of violating the rules to issue the subpoena, which it called invalid and unenforceable. Yeah, good luck with that argument in court. The Senate, as the Constitution points out, is the judge of its own rules. So did the Senate violate the rules? You have to go ask the Senate. Getting a court to say the Senate violates rules, good luck. All right. Okay. The statement also said Crows will remain willing to engage with the committee in good faith and offered information in response to Democrats' requests, but apparently not all they want. Committee Democrats have made intrusive demands of a private citizen that far exceed any reasonable standard, and to date have not explained why this request is necessary to craft legislation, particularly now the committee has completed its work on ethics. Still, Mr. Crow remains readiness. Well, they also have a supervisory role, of the courts. That's the Judiciary Committee. That's one of the things they do with their time. What am I drinking, Sahar? I'm drinking Crystal Light, fruit punch flavored. It's water with a little flavoring. It's nice, and it keeps me hydrated. Leo criticized Democrats on the panel, saying in a statement they've been destroying the Supreme Court. Now they're destroying the Senate. I will not cooperate with this unlawful claim of political retribution. Good luck. I think your odds of having to appear before a Senate committee are pretty high. You can file that motion to quash. I don't give you very good odds at all. The Senate just has to subpoena you for something relevant to their function. And I want to say there's very few cases. I think there's something on the order of 2 or 3 cases like ever where the courts have said, oh, this is outside the purview of the Senate or the House, as the case may be. There's not a whole lot of cases that have gone that way, so don't have a lot of faith or hope in that outcome. Thomas did not disclose the travel on his annual financial disclosure, but said in response he didn't believe he had to do so under exemptions for personal hospitality, which is probably true. Alito, meanwhile, traveled to Alaska for a luxury fishing trip in 2008 aboard a private jet, nice, provided by a GOP. See, we got someone subscribing. Thank you, Brian Blunt, for hitting the subscribe button on Twitch. I'm glad at least some people can figure it out. Hey, we're at 124,983. That's pretty cool. Could 17 more people please hit the subscribe button? That'd be great. I'd really like to bing over to 125, please. Could 17 of you hit the subscribe button? That'd be great. Following the reports of Thomas and Alito, the Judiciary Committee requested information from Crow, Leo, and Arkley. Leo's repeatedly declined the committee's request, and his lawyer told the panel that its inquiry lacked a valid legislative purpose. Good effing luck. They're going to have cameras for Daybell. If they actually stream that trial in real time, we may wind up covering that. They had like audio the next day, but if they have real time streaming, we may cover that trial, and then we'll read portions of his books in between breaks. That'll be exciting. Crow did not offer to provide information to the judiciary with the limited information, though what he did provide didn't satisfy them. Republicans have defended Thomas and Alito and accused Democrats of unfairly focusing on them while ignoring revelations that Justice Sonia Sotomayor's staff pushed public institutions to purchase her books, and the justices declined to recuse herself from a copyright case before the court that involved her book publisher. Go-Burger is live. Kick ass. So there's a couple trials that are upcoming that will be covering, that will get our attention, I'm pretty sure. Thomas's ties to Crow in particular have created pressure on the Supreme Court to adopt a binding code of ethics. It's not binding. We've covered it. It's all recommendations and suggestions with no enforcement mechanisms. And the Judiciary Committee advanced along party lines this summer that would require the Supreme Court to adopt an enforceable set of rules. The court announced earlier in the month that it adopted for the first time a formal code of conduct, but it doesn't include a enforcement mechanism, as I mentioned. Implementation for the ethics policy came after several of the justices expressed support for a formal set of ethics policies. Chief Justice Roberts acknowledged that in May, the court can do more than adhere to high standards of ethical conduct, and said the justices are continuing to look at things we can do to give practical effects to that commitment. My audio level looks a little high, so let me take just a moment to punch it down just a step and see if that helps. Let's try punching it down. Okay. Justices Elena Kagan and Amy Coney Barrett too expressed support for adopting the code, particularly as favored opinions of the Supreme Court fell to historic lows. We should do a fund for Jules to go to trials. That could be a good idea. Well, we can consider that. That'd be fun. All right. How are you guys liking the volume level, by the way? This is a good chance to check. Is it working for you guys? Because it seems like I ideally want to hit at -16, and it looks like I'm hitting a little bit above that on average. So I'm just trying to figure out if it's working for you guys. So just want to make sure that the audio works as I continue to make sure everything is completely dialed in. It's good? Great. Let me just take out the boost to 0. Okay. Check 1 2 1 2. Check 1 2. All right. Let's read another story. Turning our attention to potato chips. Potato chips are serious business, my friends. Potato chips. It's right in the title of the stream. Right in the title of the stream. Potato chips. Time for the potato chip stories. Police have arrested a man accused of shooting another for not sharing his potato chips. So not sharing potato chips is apparently an offense worthy of shooting another person. Or, hear me out, in the alternative, going to the store and buying your own chips. This is just a suggestion. Police say detectives arrested a man Wednesday in connection with a shooting caused by a dispute over potato chips. Police identified 42-year-old Melvin Wright as the man who shot another person in the face for refusing to share potato chips. The incident took place around 9 p.m. Tuesday outside of Lusty Adventures. That sounds suspiciously like a strip club to me. Lusty Adventures on Staten Avenue in Akron. Akron police say the victim took himself to the hospital after being shot in the face. Wow, that's interesting. He drove himself to the hospital after being shot in the face. Neat. According to officers, police found a handgun on Wright during the arrest that may have been used during the assault. That sounds like a reasonable bet. The Metro Police arrested Wright on charges of felonious assault and weapons under disability, which strongly suggests that he's a felon. What do you mean the odds are he's already a convicted felon? Oh no. He's behind bars in Summit County. Yep, that sounds about right. If in the event that you were shot in the face, maybe get someone else to drive you to the hospital. Seems probably more prudent. Get an Uber. Get an Uber to take you to the hospital. All right, so now we're going to deal with a case that potentially has really massive implications for administrative law on the federal level in the United States. So as I'm sure you're aware, the federal government has many, 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 many agencies that do many, many things, many of which touch your life in some way. The Federal Trade Commission, for example, deals with fairness in business, for a lack of a better description, regulation of trade, making sure that, consumers are treated fairly. FCC deals with regulation of television and radio. FEC deals with regulations. The SEC, which we're going to talk about tonight, deals with securities, which is typically stocks, right? So they regulate the stock market and what you need to do for stocks and your mandatory disclosures that you give, how that you're as public companies, that kind of thing. There is the EPA, which regulates the environment and deals with wetlands that may be in your home or your yard, right? And many directions beyond that as well. So the federal government has many, 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 many federal agencies that do many, many, many things. And from time to time, or actually a lot more often than that, to be quite honest, they issue fines for, not obeying their rules. They've been given statutory authority by Congress to do the thing, and they have rules adopted formally as part of the Code of Formal Regulations, and then they find that you didn't do the thing, and therefore you should pay a fine. But wait a second, what about a jury, right? Because this is essentially a civil penalty, right? So do you have a right to a jury for this? Do you have the right to go to a jury? The answer now is no. That's the answer right now. You don't have a right to go to a jury. You can go through administrative courts, the administrations have their own internal courts within the administrations, within the agencies, and you can appeal the decision internally. And then if you don't like that decision, you can take that up to the Court of Appeals, or even a district court possibly, but you can't get a jury in the first instance. And you can't even get a jury in the second instance, right? So you want, how tall am I? I'm 6 foot tall, Jules. Some people say I don't look it on camera. I'm 6 foot tall. Thank you for asking. Not 6'2", just 6 foot flat. All right, so let's learn a little bit more about whether you need juries or not. The Supreme Court seemed open to this attack on the SEC, which by implication could potentially affect all of administrative law in the federal government, and depending on where we're going with this thing, somewhat require much more out of our federal courts. It would require them to do a lot more than they're currently doing now. So it would send them a lot more business than they already have, and they have a lot of business, so yeah. I'm 6 foot tall, and I'm single, and I'm ready to mingle, or more to the point, ready to marry. And maybe my wife can live with me in my house. And maybe we can hold hands sometimes. Sahar asked, guess on this SBF sentence. My guess is 20 to 30 years. But I think a possibility beyond that that's my best guess. I also cook. I do cook. We've done cooking with Kurt on my channel. I make a good beef Wellington in particular. And I clean. As you can see, my apartment is relatively functional, not in complete disarray. All right, I keep things nice. I wash my clothes. I do dishes. I'm kind. I'm thoughtful. You're never getting married again? Oh, that's unfortunate, Jules. Oh, well. I'm sorry that apparently you will not be the love of my life. That's somewhat disappointing, but I understand. The conservative Supreme Court justices on Wednesday seemed open to a challenge about how the SEC fights fraud in a case that could have far-reaching effects on other agencies. A majority of the 9-member court suggested that people accused of fraud by the SEC should have the right to have their cases decided by a jury instead of the SEC, and by extension to any of the administrative agency's internal processes. It's just a piece of paper. No, I think that's unfair, at least to me. I don't think it's quite just a piece of paper. I think it's more meaningful than that. Um, but yeah. I'm incidentally for Tina saying the weddings are not worth it. I tend to agree. My preference, if I got married, would be for the least burdensome thing. I am more than happy to elope or get married at a courthouse. What the hell do I care? I'm interested in the marriage, not the wedding. Deep thoughts. You know, people spend so much time and energy planning the wedding as opposed to planning the marriage. It seems backwards to me by a lot. They spend so much time, energy, and money and effort for this one day as opposed to the rest of their lives. It's, you know, so I don't really care about the wedding. I care about the marriage. Commitment ceremony? Eh. We'll talk, Jules. We'll talk. We'll talk. If you're really interested, we'll talk. Um, but of course, a covenant or a ceremony doesn't have legal protections for, so that could be a problem both ways. But yeah, okay, we'll talk. You also know how to reach me, Jules. By the way, you know how to reach me. Okay, the justices have heard more than 2 hours of arguments in the Biden administration's appeal of a lower court ruling that threw out stiff financial penalties imposed on hedge fund manager who regulates the security market. Justice Brett Kavanaugh saying it seems problematic to say the government can deprive you of your property, your money, substantial sums of tribunal that's at least perceived as not being impartial. Well, that's true because the tribunal in question is within the SEC. So that's fine. I just shut you down, did I? How did I shut you down? Um, I don't remember doing that, by the way. If you're interested, I'm a lady. The man makes the first move in my world. Um, okay. I guess I'll send you an email asking, do you want to go out sometime? I told you I was single? Okay, well, send me an email. It's available, Kurt at uncivillawllc.com. Send me an email, give me a picture. What's my type of woman? Well, ideally, I'm looking for someone under the age of 35 because I'd like to ideally start a family and doesn't already have children. That would be nice. And beyond that, I want someone who's kind. I want someone who's loyal. And I want someone who gives equal effort to myself in the marriage. That doesn't necessarily require them to give equal effort in every aspect, but the amount of effort and energy should be equal, right? We should both be working towards the marriage, both intensely. So that's kind of what I want, kindness, loyalty, and someone who contributes equally and is actively trying to make it work. That's a good start. Laughter is also nice. I tell jokes. I tell jokes. Some people like my jokes. Justice Department lawyer Brian Fletcher warned the justices that their decision could have effects far beyond the SEC, noting roughly 24 agencies at least have similar enforcement mechanisms, saying, I don't really think it's just about the SEC. It's clearly not. Do I have a racial preference? Um, I don't think so. The case is just one of several items this term in which conservative and business interests are urging the court to constrict federal regulators. The courts have already ruled them in, including a decision sharply limiting the ability to police water pollution in the wetlands because they said, wetlands require, water and stuff. All right. But the Chief Justice, signaling concerns with the power of the federal government, know the impact of government agencies on daily life today is enormously more significant than 50 years ago. That certainly is very true. The administrative state has grown very, very large and impacts a lot of people's lives, sometimes in an unfair way. It would help if my wife is intelligent. The other most important quality is that I enjoy talking to her. Because, I imagine being married, we might talk to each other sometimes. And, it would be nice if that was somewhat effortless so that I wanted to and she wanted to. That would be great. Someone I can talk to, add that to the list. Last year, Divide panel of the New Orleans-based Fifth Circuit Court of Appeals ruled in favor of Jarsky and his investment group. It found the SEC resulting in a $300,000 fine and the repayment of $680,000 in alleged gains should have been heard by a federal court. So we're talking about $1 million. That's a lot. Although the Supreme Court basically dealt with only the federal court issue, the appellate panel said Congress unconstitutionally grant SEC unfettered authority to decide where the case should be treated in a court of law or handled within the agency, and said laws shielding the commission's administrative law judges from being fired by the president are unconstitutional. The issues dealing with ALJs, the judges within the agencies, are something the court has definitely spoke to in increasing degree as of late. Judge Elrod wrote an opinion joined by Odlum. Eldwin was appointed by Bush and Oldham by Trump. Davis, a nominee by Reagan, dissented. Jarsky's lawyers know the SEC wins almost all the cases it brings in front of its own judges. Surprise, surprise. But only about 60% of the cases tried in federal court. So maybe they're not as fair or open as they would like to be. The SEC awarded more than $5 billion in civil penalties in the spending year. It's unclear how much the money came through the proceedings. So this is a pretty big deal. And if you've read any or articles about it, the people on the more left-turn end of the spectrum are going insane. There's a lot of hue and cry and the sky is falling from the left-turn media, left-leaning media about this, about how this is the destruction of the federal government and all that rest. And also, unmentioned in this article, the Supreme Court is considering another major administrative decision this year, which they haven't had oral arguments for, but they are looking again at potentially overturning the Chevron doctrine from a case called Chevron versus NRDC, a unanimous Supreme Court decision, which I hate. I think it's a very bad decision. It says that agencies decide what the law is, not the courts, which seems batshit crazy. So you have a law or a regulation. There was a subsequent case dealing with that, but either way, you have a law or regulation that says, here's the power of the agency. Who gets to decide what the law means? The agency gets to decide. And the courts are obligated to follow that decision. So they get to decide what their own grant of power means and what it means. And amazingly enough, the administrative agencies somewhat tend to interpret the law and their own regulations to give them more power. Who would have thought? So the court is looking at overturning Chevron. And if they do overturn Chevron, you will see, first of all, the wailing and gnashing of teeth from the left, and you will see one of the happiest uncivils you have ever seen in your life. Yeah. I know divorce can be hard, Jules. I understand. It's one of the reasons I've been so picky up to this point in my life. My parents have been married for 50 years and they still love each other. And I really, really, really don't want to go through a divorce. And so I actually take marriage kind of seriously because I'd really like to get it right. You know? All right, let's turn our attention again to Florida. The Florida police are trolling a suspect, which I think is cute, personally. So all the rest of it. So yeah, your husband had 40 years in May. Awesome. Yeah, that's what I'm aiming for. I don't want to get divorced. All right, let's read some other stories. All right, let me just adjust the margins on this a little bit because the margins are off. Okay, apparently I can't adjust the margins, which is odd. Okay, got it. All right. The Florida police are trolling a suspect who fled an illegal street race and left his phone behind. Nice. So they're using his phone to troll their suspect. I approve. I approve. I have used Tinder in the past and other dating apps. I've mostly found them to be useless, personally. We are dying of laughter after the police in Hialeah, Florida, used a guy's phone he dropped while running from an illegal gathering as officers descend to troll him on social media. Cute. That's right. Looks like Sergeant Miller took a cheesy selfie with the phone of an Instagram user and posted along with a message of where to surrender to the police. They're posting messages to the suspect's own Instagram account. I like that. This went down the night of November 19th. So far, we don't know if the guy or Joseph Hall has turned himself in to answer for his potential crimes. But you do know he's had some sick wheels on his Dodge Charger. And apparently, that's an image of a guy, I guess. Sahar says, please, please sub. Let's get him to 125. He really deserves it. I appreciate that. Thank you. Yeah, I found dating apps to be a complete waste. Women tend to be quite a lot pickier than men, and they tend to look for, only the top tier man. And apparently, I'm not the upper crust on the dating apps, and so finding matches are tough. And then when I do, they're no one I'm interested in. They don't tend to be particularly easy on the eyes. Yeah. There's a debate about whether the 392 badge is the owner's credit score or not. That would be pretty horrible if that was. You met your husband on the 18th when you were drunk? You shouldn't be drinking at 18. We don't know if true, but sure as hell is not his IQ. Dropping one's unlocked phone, or even worse, a phone without a security lock while fleeing from an illegal race is even dumber than dumb. Facts. Facts. Yeah, Pink Stitcher says I get 600 likes a day and that I know men who use it get nothing back. That is sadly the situation of men. You ever watch those YouTube videos or things where they give a woman a phone and be like, set up a man's account and try to connect with other women? I know how to get a woman. It's easy. And then like 7 days later, they're like, this is impossible. Those are always exciting. You're in the UK, legal age is 18. Fair enough. But it even gets better. Mr. Hall's posted several videos portraying himself and others participating in other street rages as sort illegal or questionable activities. Fun. So it wasn't me. Doesn't seem like it's going very far, because his Instagram shows him in other street races using the same car, which is kind of a clue. All right. I also need to upload my emojis to Twitch. We know the real guy's name because he brilliantly linked his Instagram and Facebook. According to the latter, Mr. Hall lives in Fort Lauderdale and is from Hollywood, Florida. It appears he went to Florida State University, go Noles, and loves to wear ski masks and baklavas, as well as taking ill-advised shirtless selfies. And also, he's single, so you can date him if you're questioning. Nobody ever accused street racers of being smart, especially the older guys who keep doing it, but this takes the cake. So, yeah, that's where that is all going. So, doesn't seem to be going very well for him as well. All right. All right, we have a potentially strange story you wouldn't necessarily expect, so it'll be interesting to see what the details will. It will happen when you're least expecting it. Okay, that doesn't help in any way. And I have to be 100% honest with you, Tina. I actually get viscerally angry when people say things like that. Okay, I know you didn't mean it that way, but I'm just telling you. All right, so that's not cool with me. We have environmentalists suing the National Park Service to prevent it from planting trees, which seems odd. So, yeah. So we have environmentalists suing to stop trees. The National Park Service wants to replant sequoia groves in Sequoia and Kings Canyon parks, where wildfires in 2020 and 2021 inflicted damage on the iconic forests. The environmentalists say the planting of the trees is a huge mistake. Yeah, remember getting my perfect dream girl is as easy as going to a public library? Yeah. Yeah, I remember that. Four groups fled suit against MPS, saying the agent's efforts violates the law as it includes planting in designated wilderness areas where human involvement in the ecosystem is prohibited. The MPS announced it was planning the project this fall, saying it was concerned that natural regeneration may not be sufficient to support the self-sustained groves in the future, particularly as the fires killed an unprecedented number of reproductive sequoia trees in the groves themselves. Chad Hansen, director of the John Muir Project, one of the groups that filed suit, disputes the conclusion. Sequoias are among the species of trees that actually depend on high intensity fire in order to reproduce effectively, which I believe can be true, incidentally. But still, maybe it needs a little help to restore the forest faster. So both could be true. Nature doesn't need our help, he says. We're not supposed to get involved with tending it like a garden. Okay. Seems odd. Advocates at Wilderness Watch, Sequoia Forest Keeper, and Tull River Conservancy first filed suits against the National Park Service in September to stop a separate project by the agency to cut and burn trees in the same designated wilderness areas. So they don't like it when they cut trees and they don't like it when they plant trees. Yeah, apparently. We need to move on from the dating topic, guys. But at the moment, it's fueling my depression. We need to stop. Okay. Join the fuel reduction project. That plan would authorize cutting 1,000 acres of timber and make 20,000 additional acres subject to management ignited fires and associated activity. The John Muir Project, a nonprofit focused on ensuring federal public forests are protected, joined the lawsuit on November 17th, amending it to include the Sequoia replanting project as part of the complaint. The groups now jointly accuse NPS of illegally encroaching on federal protected lands in both of the projects. The John Muir Project was a non-profit focused on ensuring federal forests are protected. Joined lawsuit amending it to include this. Okay, we read that part. A spokesman for NPS declines comments, but confirmed replanting had already begun under the current thing. The Park Service has to abide by the 1964 Wilderness Act. Even if climate change aggravates natural phenomena such as wildfire, the Wilderness Act requires that we should still allow these natural ecosystems to respond as they want to the changes brought about in the climate. So that's interesting. Even if climate change will be moderated by this, they still don't want it to happen. That seems like a weird choice, but okay. The group also alleged both projects were approved after circumventing required process of environmental review and endangerment by declaring them emergency projects, which, I mean, kind of, because, the forest burned down, so they are somewhat emergent. High-intensity wildfires have been a natural component of the forest for tens of millions of years. True. And the forest will eventually grow back. But, we'd like to restore the forest faster if that's okay. And sequoias evolved then to adapt to and even depend on the fires. Fair enough. But again, we'd like to kind of restore it faster because, we don't want to wait for 100 years. The cones on the giant sequoia trees are ceroteous, meaning they need fire that's intense enough to melt the resin in the cone and cause the cone to release the seeds. High-intensity fires also clear the forest floor of organic material, turning it into mineral-rich soil where the seeds can take root and kill most of the trees, allowing necessary sunlight for saplings to grow. But several agencies, including National Park Service and National Forest Service, have operated on the Smokey the Bear mentality. Nice. Treating natural fires as need to be suppressed and prevented without understanding their role. So they don't like it when they try to prevent the fires. They don't like it how they respond to fires. You can never make anyone happy, man. Everyone's going to complain. The more agencies will allow natural fires to burn or perform its role, the burnless the forest will be. Yeah, but maybe it'll burn down some houses too, so that's an issue. The NPS has stated in its public project announcement only replant in areas that show insufficient natural regeneration for forests to successfully reestablish as they would have done naturally had they not experienced the fires. I'm sure given enough time they would, but we'd like to help it out, which seems fine to me. Thank you for the 222 of you watching, by the way. We're still trying to hit 125,000, and we're right on the edge. We need something like 10 more subs or something. So if you haven't subscribed, now would be a really great time to hit the subscribe button so we can pass the 125,000 mark. That'd be great. Please. They believe after analyzing 3 decades worth of geological data and satellite imagery of wildfires that the planned interventions has had the opposite of what is intended. What we found is that forests with the fewest environmental protections and the most tree removal have the most intense fires, even in the same forest types. Fair. If the NPS is allowed to proceed, it would set a terrible precedent for wilderness. But strongly believes the court will side with the plaintiffs. I hope he does. Contrarian gifts 5 gift memberships. Thank you, Contrarian. It makes me feel a little bit better. Thank you. What we found is the forest, okay, if NPS is allowed to proceed, it said that precedent We know what the Wilderness Acts and we know how the courts have interpreted, and that's why I'll believe. Well, I can't speak to the Wilderness Act. I've never read that one. You got me on that. So my extensive knowledge of law does not include the Wilderness Act. So I don't know the answer on that one, so I'll take a pass. Uncivil knows a lot, but doesn't necessarily know everything. We found something Uncivil doesn't know. And that's the end of the story. All right. Okay. In the person convicted didn't do it news, which is always disturbing, right? Especially and particularly where the police knew better and or withheld evidence and or framed the guys and or such. You know, there's unfortunately stories like this in injustice, and it always makes you a little sad. Does the EPA also get to interpret its own rules? It sure does. Yeah, of course it does. All right. Two men are exonerated in a 1990s New York City murder after investigators find unreliable testimony. Exciting. Two men who served decades in prison for separate murders in New York were exonerated on Monday after investigators found they'd been convicted based on unreliable testimony. What are the odds? Jabbar Walker, 49, walked free after being cleared of a 1995 double murder. So after 28 years. Michelle NC gifts 50 gift memberships. Wow. That's quite the generous donation, Michelle. Wow. Thank you so much. That's a very, very generous donation. I really appreciate it. That's very, very kind of you. Thank you. Wayne Godin, also 49, convicted of the 1994 murder, was exonerated after being paroled last year, but also accused of entering the United States illegally as a teenager and now facing deportation as well. Both crimes took place 8 blocks apart in Harlem, and both convictions were vacated after defense lawyers worked with the district attorney's office review unit to clear the men's names. Walker, who was represented by the Innocence Project, was 20 years old when he was arrested for the shooting deaths. The new investigation of the case found police had pressured a witness to incriminate Walker by implying they charged him with the shootings if he didn't cooperate. Yeah, that's not great. The witness later recounted his testimony. Another witness who said she'd seen the shootings have received monetary benefits from the district attorney's office, which wasn't disclosed. That's not great either. Mr. Walker received a sentence that could have been processed in prison for his entire life, says the district attorney. I'm thrilled we can finally return him home and thank the Innocence Project for its steadfast advocacy throughout the matter. Hey, blessed by God, glad to have you here. Walker entered the Manhattan courtroom in handcuffs and left a free man. New York Times reported that Walker silently mouthed, "I made it," when the justice vacated his conviction. Gardine was 20 years old when he arrested for the fatal shooting of Robert Mickens, who was shot a dozen times. His conviction was vacated after the reinvestigation from the district attorney's office and Legal Aid Society found that the single eyewitness, which isn't exactly the greatest start to a case, had pinned the killing of Gardine to please his own drug boss, who was friends with the victim. So that's super exciting. Unjust convictions are the height of injustice. They sure are. Better 10 guilty men go free than one innocent man go to prison, as they say. I hope this is the first step in allowing Mr. Gardine to rebuild his life and reunite him with his loved ones. Gardine was paroled last year after 29 years behind bars. 3 decades of his life gone because of this. I mean, truth be told, I probably would have self-deleted in my cell long ago if I were him. You know, I don't know. Maybe he's made of sterner stuff than me. We're elevated that Mr. Gardein will finally have his name cleared of his conviction that has haunted him for 3 decades. Yet he's still not a free man and faces additional unwarranted punishment if deported. And that brings us to the end of that story. What should the punishment be for prosecutors that frame people? Should be pretty harsh, I would think. Monetary benefits for testifying? Well, it wouldn't be for testifying exactly, presumably. It wouldn't exactly be you testify, we give you money. Presumably what they mean, although who the hell knows, is that the prosecutor was helping them with incidental expenses relating to them testifying. For example, I don't know, they needed to move them to a safe house or something, or transport them the thing or whatever. Like, so there might be some incidental expenses relating to them testifying, depending on details. But either way, that needs to be disclosed because it's potentially biased, right? So I presume that's what they mean. Factoid does not mean small fact. It means common misconception. Okay, let me look it up. Let's see. What does the dictionary say? Factoid, noun. An invented fact believed to be true because it appears in print, or a briefly stated and usually trivial fact. So it seems like it goes both ways. But I didn't know the other definition. That's pretty cool. Cambridge Dictionary says an interesting piece of information. So different dictionaries have a dispute. Wikipedia says factoid is from fact plus oid, similar but not the same, which it was coined by Norman Mailer in 1973, which according to his biography defined it as facts which have no existence before appearing in a magazine or newspaper, creations which are not so much lies as products of manipulation. And then, so it's an accurate statement or statistic believed to be true, especially if cited, and originally in the U.S., an interesting item trivia or a minor fact. So, at least in modern English, it goes both ways. That's neat. I learned something. I like that. Yeah. Words, of course, evolve over time. Right. So, Norman Mailer, who invented the word, had a specific meaning in mind, but the word evolved. That happens, right? English, in particular, is a descriptive language, not proscriptive. So dictionaries show how the word is being used, not what it's supposed to mean, in some sort of like desired sense. So words evolve and change. All right. Now, this is an interesting case. A person who posted a ballot selfie in Wisconsin has had the felony discharged. Okay. A local official who had posted a photo of his marked ballot on Facebook had felony charges dropped against him. All right. So let me talk a little bit about this issue. Okay. Many states have laws against taking photographs of your ballot. There's a very good reason for this, if you think about it, right? We want, right? Someone might sell their vote, for example. We don't want you to sell your vote, right? And like, how do you prove to the guy you sold it to that you did what you said? How do you prove it, right? So a photograph would show it. Well, here's my ballot. Here I did what you said, right? Or even more nefariously, someone is threatening you, right? Vote for person X, or we're going to hurt you, right? So the secrecy of the ballot is meant to protect you as well, because you can't prove which way you voted. Then there's no way for the guy who's threatening you or bribing you to verify that you did what you said, so you can just lie to them, because there's no way to verify it. So the reason to not allow photographs of ballots is to preserve the secrecy of the ballot, so you can't sell your vote, you can't be coerced into your vote, You can't, your husband or wife can't confirm that you voted the way you did. Show me your ballot, honey. Make sure to show me your ballot, or you're really going to get it tonight, right? So that's why the rule exists, is to protect the person voting. Michelle NC gifts 50 gift memberships in the chat. What an incredibly generous chat, becoming so many people into the U.S. How do you sell your ballot? You sell your vote, right? So you don't, strictly speaking, sell your ballot. You sell your vote, right? So someone comes to your door and say, will you vote for candidate X? No. What if we pay you $50? Okay. Right? So you sell your vote. So then you go to the polling place and vote on the ballot according to your deal and take a photograph of it to confirm that's what you did, and you get for your $50. So that you sell your vote. That's how you would do that. So yeah. All right. So anyways, let's turn our attention back to the case. Sounds like abridgment of freedom of speech. Yeah, that's what the court decided. But the reason for the policy goes to the right to vote, which is also a right as well. So there's some countervail. How do you sell it? I just told you, right? Someone who's interested in buying votes for a campaign, some enthusiastic person who's working for a campaign, really trying to round up the votes, I don't know, stands on a street corner or something, said, sell me your vote, $50. I don't know what they're doing with their time. And or they put an ad on Facebook or Craigslist, or they approach you privately and say, hey, would you like to vote for person X? We'll pay you $50. That's how you'd sell it. Yeah. Okay. So anyways, this guy had his felony discharged. Paul Bazell, 52, Ameriquin, faced maximum penalties of 3.5 years behind bars, which seems pretty extensive. Seems like a pretty harsh penalty, incidentally, for violating this rule. Doesn't seem like it's worth 3.5. Yeah, some local campaigns come down to a small handful of votes. Yeah. Yeah, fair. Exactly, Tony P. Yeah, there you go. So you're not just necessarily looking at the top, candidate. You're not just looking at president. Often, local elections can turn on very few votes, particularly in off-year elections. So there you go. The judge dismissed the charge in a hearing, saying state law prohibiting voters from showing their ballot to anyone else is a violation of the Constitution's freedom of speech. I don't know that other courts have ruled this way. Incidentally, the state may appeal this issue. We'll see how it goes. 3.5 years seems like a lot, though. The case was more than just about a Facebook post. It's about protecting a fundamental right to freedom of expression. But there's also the right to vote, which implies a whole bunch of things. So there are some countervailing considerations. The district attorney who brought charges against them promised to continue pursuing the case by asking the attorney general to appeal. Didn't respond to a request for comment from the Journal Sentinel. There's been a movement in other states allowing this as well. In New Hampshire, a federal judge held the state law barring individual right to publish their ballot violated the First Amendment. And Michigan legislature changed the law to make it legal. Wisconsin Senate passed the bill, but the proposal died in the Assembly. Candidates for office have sporadically posted photos of their ballots in apparent violation of law. So, yeah, that's the situation, what's going on. So we'll get in. In Washington State, all ballots are mailed in. About 10 years ago, people came through my neighborhood and have gift cards for people they assisted in filling out the ballot. Sketchy shit, man. Sketchy shit. Sketchy shit. So that is that story. Yeah. Now, this story is like one of my personal nightmares. Okay? So if you want to understand the psychology of uncivil, this happening to me would be like one of the worst things I could possibly imagine. I imagine you wouldn't be thrilled either, incidentally. It's not something you're going to probably like, but this is like my room 101 for the 1984 reference. This is like This is particularly heinous for me. This goes to a whole new level of horrible. All right. So you may have seen the story in the news already. A suspect who was running away from the police with respect to a hit and run went onto a golf course and hid in a porta potty, and one of the people who saw this happen then went to the porta potty and pushed it over with him inside, causing the contents of the porta potty to, envelop him. I'm dead serious. I'm dead serious. This is freaking me out. Yeah, this freaks me out. Yeah, that is, yeah, just put me in jail, man. Give me a break. All right. Police chase ended in a porta potty Wednesday after Glendale police attempted to pull over a driver in a stolen car. It all begins with a crash on I-43. According to Glendale Police Department, officers located a Dodge Durango, which is stolen out of Plymouth, on 5400 block of Port Washington Road. I also believe I have a somewhat irrational fear of death by escalator. I take escalators, but I'm more worried about them than I think the average person is. Officers saw the driver driving recklessly, and officer attempted to deploy stop sticks. The driver drove into oncoming traffic and caused a crash with two other vehicles. The four people inside the vehicles fled from the vehicle and ran from the police, who were not far behind. Golfers at the golf course saw the police speeding across the green. A video taken from the golfers, which is on the west side of the highway, shows police officers surrounding the porta potty. It's where they found one of the suspect trapped after a golfer stepped in and pushed the thing over. I agree with you, Texas. There is not enough water and soap in this world. There is not enough water and soap in this world. When we realized they were being chased and the kid was in the porta potty, we tried to tell a police officer he wanted to chase the other one. I just made the rash decision to push the porta potty. Two people were taken into custody. Dude, man. Dude, give him time served. He's already been punished enough, man. Damn. Give him time served. The drivers of other two vehicles involved in the crash were transported to a local hospital with non-life-threatening injuries. Just kill me. Just kill me first, please. Just kill me. Yeah. Play the video? I don't want to. It's a nightmare of mine. I don't want to play the video. You watch the video on your own time. No. Turning our attention to the Lufthansa heist from the movie Goodfellas, we turn our attention to Canada, in which there's a legal dispute over who is responsible for $24 million of gold that was stolen in a heist from the Toronto airport. Someone stole some gold, and we want to figure out who's responsible. Exciting. An airline and an armored car company are in a dispute in a lawsuit about who's to blame for all this. A gold heist at Toronto's main airport, which thieves seared nearly $17 million US worth of gold bars and cash, is still unsolved after more than half a year. The airline and armored car company that handled the cargo are now blocked in a lawsuit, with each saying the others to blame for the heist. In April 2023, 24 gold bars and nearly $2 million of cash were stolen from the airport cargo warehouse at the airport after a fake waybill was used to claim the cargo. So all they had to do was fake a piece of paper, their ticket, that says, "Hey, this is my property. This is my property. Okay. It's your property. Take it. Yeah. In October, the American cash handling company Brink's alleged in legal filing that Air Canada's lax security allowed the thief to make off with valuable cargo in his hold. Now it's emerged that Air Canada has countered, alleging Brink's shipped the gold and cash from Zurich to Toronto without declaring its value, failing to add insurance, and declining to pay extra for security. That doesn't sound great. Yeah. Yeah. The Brink Switzerland did not request from or pay for Air Canada or for any insurance with respect to the cargo carried on this waybill. Yeah. Electing it's for its own reasons not to declare the value of the carriage, not to insure the shipments, instead pay standard rate for services. So they didn't give the airline fair notice about what was in the packages or how much they were worth. So they didn't know to take extra steps or extra security because you didn't tell them. That's neat. The Brinks lawsuit says thieves easily stole the gold by simply using a falsified waybill because Air Canada's measures at the facility are insufficient. They may have done more due diligence if they understood the value of the thing involved. I'm just guessing. I'm guessing the procedures probably differ a little bit as the value goes up. Just a one man's guess. Both companies have invoked the Montreal Convention, nice trick, which regulates international shipments and sets compensation limit for cargo. Yeah, so all the countries basically have agreed for what damages are for airline related issues, so we don't have to deal with what jurisdiction you file it in, so we all reached an agreement. But this was off the plane at the time, so I'm not sure the Montreal agreement applies, but hey, give it a shot. Brinks, however, argues there's no limit to compensation. Brinks also said it paid extra for the shipment and marked the waybill so they knew the cargo contained banknotes and gold bars, adding it requested special supervision. Maybe not enough, though, because you didn't tell them how many gold bars or what it was worth or anything else, so I'm not sure that was enough. Gold bars and money, what does that mean, right? Yeah. So, yeah, that seems how that's going, so that is the direction things are heading, and without any trace of the thieves, even 6 months later. So that was wild. All right, last story for the evening. Last story for the evening. Where are we at on subscribers right now? Let me check on my back end real fast. How close are we? Let's look. Channel management, analytics, I think it is. See live count. 987. We need 13 more. We need 13 more. So if you would hit subscribe, I'd appreciate it. Thank you. There's got to be 13 of you who haven't hit subscribe. There's got to be 13 of you who haven't hit subscribe. Alex Jones is back in the news as Sandy Hook families have offered to settle the $1.5 billion judgment they got for $85 million, which is one hell of a reduction. Now, I take note that I was very critical of the amount of damages award. A significant amount of the damages were for false advertising relating to his supplements. Right, so obviously there was a defamation claim for saying Sandy Hook never happened and the people were faking it and there were actors and they're still alive and all the rest of it. So that was part of it, but a lot of the money was due to allegedly falsely advertising his products, and they basically applied the damages to every single individual sale, which doesn't seem like right. So the damages really accumulated a lot. And so they really went out of their way. So I was very critical of this damages. That seems like a very, very excessive damages. So he filed for bankruptcy, which wouldn't normally cover an intentional tort incidentally, but might cover the part dealing with the products, because that wouldn't be the same thing. And so they've offered to sell for 85 million, which is a much more reasonable number. I'm not sure Alex Jones is interested in paying that, but they've given him the option, so that's where we go. Yeah. Share with a friend, share on Discord, ask for subs. We're not beyond that. Shanny Hook families, who had won the $1.5 billion in legal damages against conspiracy theorist Alex Jones, at least in part, for calling the 2012 Connecticut shooting a hoax, have offered to settle the debt for $85 million paid over 10 years. So that would be a lot more viable. The offer was made in Jones' personal bankruptcy case in Houston, and legal filing lawyers for the family believe the proposal is a viable way to help resolve the bankruptcy reorganization of both Jones and his company. But in the sharply worded document, because they're not going to take any, restraint to bash him on the record, the attorneys continue to accuse the InfoWar host of failing to curb his personal spending and extravagant lifestyle, failing to preserve the values of his holdings, refusing to sell assets, and failing to produce certain financial documents. He's making it very painful for you. Jones has failed in every way to serve as the fiduciary mandated by the bankruptcy code in exchange for the breathing spell he's enjoyed for almost a year. Bankruptcy proceedings, by the way, freeze everything. So as long as the bankruptcy is proceeding, the moment it's filed, there's an automatic stay at law. So filing bankruptcy is an outstanding way to freeze every action against you. Are you in foreclosure? Do you not want to be foreclosed on? File bankruptcy. Whatever, because it freezes everything. The family lawyers offered Jones two options: either litigate his estate and give the proceeds, or pay them $8.5 million a year for 10 years, plus 50% of any income over $9 million per year. So they basically want him to pay all of his income up to $9 million and then 50% of any income beyond that. During court hearing from Houston, the Burchell bankruptcy lawyer suggested Monday that the $85 million 10-year settlement was too high and unrealistic. There were no financials that ever show Mr. Jones ever made that in 10 years. Possible. In a new bankruptcy plan on November 18th, Free Speech System said it could afford to pay creditors about $4 million a year, down from an earlier estimate of $7 million to a $10 million annuity. The company said it expected to pay about $19.2 million next year, or make 19 from selling its dietary systems, clothing, and other merchandise Jones promotes, while expenses would be about $14.3 million. Personally, Jones listed about $13 million total assets in his most recent financial statement, indicating about $856,000 in various bank accounts. So he may not have the money. He may not have made the money. I'm not on the inside of knowing exactly how much Alex Jones pays or makes, so I don't know what he makes. Under the bankruptcy order, Jones has been receiving a salary of $20,000 every 2 weeks, or $500,000 a year, which sounds pretty good to me. But this month, the court appoints restructuring officer upped Jones' pay to $1.5 million a year, saying he's been grossly underpaid for how vital he is in the media company. Nice. Bankruptcy judge on Monday rejected the $1.5 million salary, saying the pay raise didn't appear to have been made properly under the law and a hearing needed to be needed. Sounds right to me, right? Because, the company is being managed under the bankruptcy proceedings, so the judge has to approve it. After the 20 children and 6 educators were killed by the gunman at Sandy Hook in Connecticut 2012, Jones said repeatedly on the show the shooting never happened and was staged in an effort to tighten gun laws and other stuff like that. Relatives of many but not all the families sued in Jones and Texas, winning $1.5 billion in judgment. The judge ruled that Jones could not use bankruptcy protection to avoid paying more than $1.1 billion of the debt because it goes to an intentional tort. Relatives of the victims testified at trials about being harassed and threatened by Jones believers, who set threats and even confronted the family, accusing them of being crisis actor for children who never existed. He's appealing the judgment, saying he didn't get fair trials and his speech was protected. So that will keep ongoing for some time. We're at 994. Are there 6 more of you who haven't hit the subscribe button? I'll sing, or not, depending on whether it'll please you. I don't want to wait for our lives to be over. Do 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 do. I need a hero, baby. Someone wash away my tears. You are my everything. Please hit subscribe. Just got here. Swoop. We can watch it. We can do a swoop. 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 Yeah, interesting. That's fair. Rachel Maddow and others on the left say whatever they want, and they're not really taken seriously. Well, in the Alex Jones case, in Connecticut, Jones never got, excuse me. Let's try this again. In the Jones case in Connecticut, Jones never got the chance to argue that issue about the Rachel Maddow defense. You know, no one takes me seriously. He never got the chance to make that argument because the judge ruled him liable as a sanction for discovery violations. So the judge said, how about you did it? Which, you know, is a possible sanction in a civil case. Obviously, you can't do that in a criminal case. How about the sanction is you're guilty? You can't do that. But in a civil case, one of the potential remedies for fucking around with the court is how about, yeah, you don't get to put on a defense. You did it, and now we just talk about money. So he never got the chance to say, you know, I'm not liable because, like Rachel Maddow, I'm just an entertainment program and no one takes me seriously anyway, because the judge gave a default judgment against him. So that's what happened in that case. Yeah. And I read the court's decision, and that decision, I believe, was upheld. I believe that issue already went to appeal, and possibly the Supreme Court, if I remember my case history later. Or in any case, I remember reading it. We read, maybe that's not true. Maybe because we read a couple of the default judgments that have been made against him and the court's findings, and it did seem like a lot. It did seem like he was fucking around pretty hard in sort of not giving discovery. Remember how you guys were so pissed at Johns Hopkins for not giving discovery? Remember you were so pissed they didn't overturn the IJ, right? And for whatever reason, this judge didn't seem to sanction them for their many, many discovery violations. Yeah, we lost it in a river. Our phones are dead. They're lost on server farm. Where I'd be inclined as a judge to say, bullshit, that's not true. You're lying. Produce it. Right? Because I can do that as a judge, because I can find things that are not the case. Right? I can't make a decision as a judge as to the case, like the underlying issues, you know, like that, unless I'm going to default. But I can make findings of fact as they relate to things outside the case. For example, hey, we can't find it because we lost it in a server farm. Bullshit. You know, you didn't turn over the IJ. Fuck you. Turn it over. Right? So the judge in the Maya Kowalski case could have issued sanctions up to and including, how about you, Johns Hopkins, just lose? How about you turn it over or you lose? How about that? Right? So, you know, so for whatever reason, I can't speak to that judge's temperament, but for whatever reason, he doesn't want to appear to sanction anybody, which seems like a very odd move to me as a judge. You need to exert your authority as a judge, or they're going to roll over you, right? You need to exert your authority and, you know, keep and whack them back in line. So I can't really speak to why the judge made the decisions he did, but he could have taken actions. So, yeah. I think it was Robert Barnes who claimed Jones produced more discovery than many cases, and he was still a victim of summary judgment. Yeah, I didn't hear what Robert Barnes had to say about the issue. I can say that I read the court decisions in like 4 or 5 related decisions, because there were some related decisions in Texas as well. I think in other cases, right? So there were a couple decisions, both in Connecticut and Texas, um, dealing with essentially similar issues or comparable issues. And apparently, Alex Jones's fucking around with discovery has been found multiple times in multiple cases in multiple jurisdictions. So, there seemed to be uh, a fair amount of evidence, because it's like, the judges aren't probably all corrupt in all these jurisdictions. So it seemed to me, at least on the surface level, the judge laid out their rationale. So all I read was the end decision, right? I just read the end decision, as I often do. And like, okay, does this make sense? And I read it and I'm like, oh, okay, this seems to make sense. It's surfacely, it's on its surface rational. So that's what I thought. I thought it was going to be December 15th about sanctions. Yeah, but he should have decided these issues a long time ago. He withheld sanctions. He should have issued sanctions during trial. He should have told them to fuck off during trial. Yeah. And the judges could be spilling bullshit in the respective cases, but the fact that it was multiple different courts in both Connecticut and Texas in multiple different cases somewhat increases the credence that this is happening. So I was somewhat willing to take, the multiple decisions that all seem to be dealing with Alex Jones's propensity to, not play nice in discovery. I was like, well, all these judges probably aren't corrupt. So, I was like, yeah. Yeah, what disincentive is there if there are no repercussions? That's what I say. That's what I said. I don't understand this judge when it comes to not issuing sanctions. You start with financial penalties, which incidentally they did in Alex Jones as well. So the sanction of default judgment was not the first thing the courts did in any of these cases. You'd have to fuck up pretty fucking hard. You'd have to really try really hard to get default for like fucking around with the process, right? As opposed to summary judgment or dismissal because it's not viable at law, right? So we're not talking about that. We're not talking about dismissal because you don't have enough case or summary judgment because your facts don't work. We're talking about dismissal because I hate you because you fucked around, right? So things outside the case. You'd have to try really hard, really, really hard to get default as the first remedy. The courts tried other things. They tried fining Jones. They tried increasing the fines, and other things like that. So they tried other steps, and then they got sorted to the end and they're like, well, nothing else has worked, so default. You kept fucking around. We tried to whack you back into place. You didn't take the guidance, so get the fuck out of my courtroom because you're not playing nice. There are rules here. You're not playing nice, so get the fuck out. Right? So I don't understand the judge in the Maya case. I really don't. The failure to produce the IJ would turn me ballistic. And also I would have a hearing when they say things like, oh, that video was lost. That's lost in a server farm. All of our cell phones were destroyed. I'd be having a hearing, and somewhere around, the third or fourth of the dog ate my homework, I'd be saying, okay, I no longer believe you. I believe you've been lying about all these things because that just doesn't seem possible to me, which I can do because I'm a judge and I'm listening to these guys and be like, I think you, counsel, are lying to me. So produce the things or get sanctions. And the sanctions are going to start going up. And they keep going up until you do what I want. It's $1,000 the first day, $2,000 the second day, $3,000 the third day, $4,000 the fourth day, or something like that. We can keep doing this as long as you want. Fuck up. Fuck you. Pay me. Give me my IJ. Give me my records. Give me my data. Fuck you. Pay me. And eventually, if they don't do it, I'm like, how about you just fucking lose? How about you lose? You summary default judgment because you fucked around. So I really don't understand the temperament of this judge, because Rob told me that there were 52 summary judgments. That is absolutely batshit crazy. I don't know that I've heard of a case with like more than like 2 or 3. Normally there's only 1, unless something changes, but 52 summary judgments? Are you fucking with me? And apparently you guys told me it took 15 hearings. 15 hearings to get the iCloud data? It should take exactly 1 hearing. It should take exactly 1 hearing. What you do is you bring the parties before you. You give them notice what the issue is. Presumably this is an motion to compel discovery, presumably, right? So you bring the parties in and like, okay, talk to me about what's going on. You listen to both sides, you give them both due process, and you make a judgment. Okay, I hereby order the compel. If you don't do it, that's contempt. And so you don't do it. They file a second notice. Hey, they still haven't done it. Like, so now it's the second time. Hey, they still haven't done it. The next thing the court does is an order to show cause. That should be the next thing. Show me cause why I shouldn't whack you with the stick. So you have a hearing about that. Show me why I shouldn't I shouldn't whack you with a stick. And short of, insert very understandable external factor in this sentence, some external factor that precluded the attorneys from, doing it. For example, there was a hurricane and we had to flee because, hurricane, that'd do it. There was a tornado and, the stuff was destroyed because, tornado. My wife was really, really sick and I had to go to the hospital because, that was really important. So short of something like that, fuck you. Now we're talking about contempt. Now we're talking about damages. Now we're talking about give me money. Give me money and keep giving me money until you do it. So why there was more than 2 hearings is beyond me. Every attorney should just require 1. Right? You just have 1. You get fair notice about what the issue is. You go to the court. You have a fair argument about what it is. You exchange the information. The judge makes a ruling, and you obey the ruling because you're an officer of the court. So it really should take 1 hearing. But you guys told me it was 15. The fact that it was 15, if it was 15, is like mind-blowing to me. It should be 1. And if it needs to be a second one, it's because of order to show cause, at which point I'm whacking you around. And if you keep doing this, at some point I default you because you've been fucking with the court. I suppose the judge, as part of their sanctions now, if he were so inclined, although I'll doubt it, I suppose he could say the jury ruled against you, but as an additional sanction for you ruling out, I also fined for default judgment in the alternative. Now, that would preserve the jury's decision as to liability. Because, in the alternative, I sanction you by default judgment, so take your pick, which that would be cute. But this judge doesn't seem like the kind to do that. Ann Ramondson gifted 5 gift memberships. Thank you very much for the gift memberships. I'm still waiting for 5 more subs. I'm looking at my back end, and it's 995. There's got to be 5 people out there who haven't hit subscribe. I'll do the beef fish if you give me 5 more subs. How about that? Will that induce you? Do you like the beef fish? What else can we talk about? Oh, that's right. One of you guys sent me something. You guys sent me an additional document we could talk about. Let's take a look. I remember now. All right, so let me see where that document is. Hold on. You guys sent me Something about Alan, I think. I seem to vaguely recall. Okay, hold on. All right, here we go. Oh, right. There's a motion to leave to respond to judge and AG along with the response they'd like to file. All right. Let's see what this is. Realtor's response. We've read this. I think. Oh, no, is this a different document? I'm confused. Did we read this or not? Yeah. Maybe you guys will convince me I was wrong about State Jones versus Knox. Because they cite that like in the second thing. So if I have to take back my analysis, then that's fine. Let's see. Where is the thing that I already read? So this is Realtor's. This is Realtor's response to respondents and Attorney General's objections. What was the other one I read already? Let's see. Where's the... response to Realtor respondent? Respondent's brief. No, where's oh, here it is. Here's the one I need. Brief in support, Realtor's brief in support. This is 21 pages. And the one you just sent me was 18 pages, and it's titled differently. All right, so cool. We'll read this. See if it changes my mind as it relates to the Delphi murders. How about that? Would you guys like that? Would you guys like me to talk about the Delphi murders some more? Do a little bit more legal analysis for you guys? See if it changes my legal analysis at all? Let's see if it changes the legal analysis at all. You know what I want to do, though? I think I want to do it as a new stream. So let me set up a new stream because someone might want to just watch that part. So let me just do that. So let me set up a new stream and I'll redirect you that way. How about that? And we'll do that. That makes more sense that way. Okay. So I need to figure out how to do that. So how do I do that? I think I have to do it within YouTube. Okay. Let's do it this way. Okay, create live, go live. Okay. All right, so create a new stream. Create a new stream. Next. Oh, there's the option to turn off mid-rolls. Oh, okay. I now see the option to turn off mid-rolls, so I can turn off ads, I think. Let's see if it works. Next. Public. We're going public. Now. If I create it on YouTube's end, I can turn off the ads. So if I actually create it within YouTube, I can turn off the ads. Okay. Note to self. This makes it a little inconvenient, but it's possible at least. Okay. That's neat. All right. So what am I trying to do? All right. So I'm trying to set up a redirect from the stream I'm already having. All right. Delbell updates. What updates were there for Daybell today? Redirect. Do this. Okay, great. Set that up. Save. Okay, great. All right, so I have a new stream set up now. So hypothetically, this should redirect you to the next place. I'm going to take about 5-minute break. All right, to stretch my legs and stuff, and then we'll read this. And if there's something on Delphi or Daybell to extradition, I don't care about that. She's gonna be extradited. I don't care. All right, so I'll see you guys in about 5 minutes on the other end. I've been on civil law, and until later, my friends, I hope all is well. And if it doesn't redirect you, you should be able to find it on my channel page. Until later, cheers, my friends, and goodbye.